I call to order the 9th meeting of the Bills Committee on Marriage Amendment Bill 2014. Please invite government officials to join us in the room. All right, so we've just met yesterday. And we started the clause-by-clause scrutiny of the bill. Yesterday, the administration promised to give us a sample of the affidavit to be made by parties intending to or intended to get married, and the relevant paper is tabled for our information. And we were on clause 3 of the bill. So can we follow the marked up copy as well? Paper CB2 1203/1314-02, the Chinese version. Mr. Tommy Zhang. Chairman, since the administration has prepared a paper for us, aren't we going to discuss it? It's just the affidavit. So we're not going to discuss the content? It's just for information. Okay. Page 1 of the marked up copy. Section 41. Every marriage under this ordinance shall be a Christian marriage or the civil equivalent of a Christian marriage. There is an amendment here. DS, please. Please introduce the amendments on this page to us. Can I defer to Mr. Wu? Thank you. We propose to add new section 40A, which is the core of the bill. And if a person has received a full SRS, then the person is, for the purpose of this ordinance, to be treated as being of the sex to which the person is reassigned after the surgery, and the references to men and women in Section 42 and the references to male and female in Section 21D of the Matrimonial Causes Ordinance are construed accordingly. We propose to add this new section because the CFA has ruled that Section 42 of the MO and Section 21D of the MCO requires the biological sex to be taken for determining the sex of the person concerned. And so we have to propose this section to change to follow CFA's ruling. Legal advisor, well, I have a drafting point, and that is new section 48(2) bracket B, Roman 2. B targets surgery from female to male, and Roman 2 here says constructing a penis or some form of a penis in the person. Some form of penis. I'd like to know the scope of this, because the presumption under 40B is such that a person holding a valid travel document can be used to prove his sex. Now, if a person is in possession of a valid travel document, now he is a man, but he has gone through the situation described in 40A2B2. So he is a man after a surgical procedure described here. You say here some form of a penis. If the person concerned is not too sure whether his form of a penis is in line with what's required in the law.
As Mr. Chen Chi-chun said, what procedure can help establish his male status at the time of registration of marriage? The administration, Mr. Wu, to respond to the question, penis or some form of penis, the wording, as we explained in previous documents, the hospital authority experts have explained to everyone that the medical sector has a consensual understanding of this wording, so the construction of penis is a difficult surgery. Now, if a person doesn't have specific requirements for his penis to be constructed, then it can be a simpler kind of surgery, and that can be understood to result in some form of a penis. Now, if that person had undergone surgery abroad, and if he is required to provide proof, the immigration staff can look at the medical certificate provided by him, whether that certificate explains that he has met the requirement of having a surgery to construct some form of a penis. So he has to produce a certificate produced by a hospital or a medical expert. Yeah? Yes? As Chairman, now, firstly, the Registrar of Marriages may have some doubt on whether that level is reached, or that person has some doubt, and in that case the person can produce a certificate, and that is similar to certificate produced available here in Hong Kong, and when the surgery is completed here, the medical staff can produce a certificate, make a certificate showing the scope of the surgery, and this will show whether some form of penis has been constructed. Now, if the Registrar of Marriages still has further doubts about the certificate, he can further inquire or verify with the hospital authority or other medical expert. Thank you, Chairman. Now, some form of, now that can cover a wide range of situations. That's correct. Yes, because when females transform into male, it can be quite complicated. Now, I am also addressing 40A2B2. Now, some form of, that's very unclear wording. Now, the government says that they are going to produce a sample, but actually they produce a document only. Now, do you have medical guidelines? Does the hospital authority have any document to support this? Because it's very unclear in the bill. Do you have a picture? Now, some form of penis may be insertion of cartilage or insertion of an air sac. Now, is there a strip of skin, a small piece of flesh construction? Will that meet the definition? And if a person for some reason loses the penis, maybe due to accident or by some act of the person concerned, then will that definition be void, that his change of status from female into male? Now, our wording in the draft is according to medical opinion, and this opinion has been used for reference in the reaching of the decision by the CFA, and previously we sent a reply to the legal advisor on 30th of May. Now, according to the principles issued by World Transsexual Association, now in the construction of genital organ in a transformation from female into male, the construction will be a consideration by the person concerned, and the a paragraph in the CFA judgment has listed out the opinion of the medical expert, where Dr. Yun gave details of the surgeries required for transformation of male into female and female into male. Now, Dr. Albert Yun's description, I believe, already covers what is done, the parts of the person concerned that are used to construct a certain form of penis or of a genital organ. A second question, please. Now, if the surgery has been done and then the penis has been lost, now right now the bill says that it will be according to the ID, and it all depends on the medical certificate. So the administration is saying that if it's done, I get the certificate and then I cut it off the next day, I will still meet the bill's provisions. DS, Deputy Secretary. Of course, it depends on the facts. That is, the person, when he or she goes to get married, whether he meets the legal requirements. Now, as for what happens after the marriage, now I am talking about the interval of time after before he gets married. You mean after he got the ID? That is, after he got the marriage certificate, and then he destroys the genital organ. Now, the marriage ordinance is that person has to meet this criterion when he gets married. So in the marriage procedures or process, as we shall inform later, the married person has to serve notice and he has to make an affidavit before the Registrar of Marriages in which he says that he meets with the legal requirements. There are no legal impediments. Now, if he's a transsexual, he has to understand the legal requirement. That's why we need statutory law. The person concerned shouldn't have the misunderstanding. The law says that at the time of transsexual surgery, he has undergone the surgery. But when he gets married, at the moment he gets married, does he have to produce proof, take off his pants, and demonstrate that he is still meeting the requirement? So before he got married, or he got the certificate, and then it's all done, and then the reconstructed genital organ is destroyed or accidentally lost, then will that still be in accordance with the law or not? It depends on the facts at the time of marriage. At the time of registration, when he makes the affidavit, at that moment, he has indicated to the registrar that he identifies himself as meeting with the requirement of the MO. Mr. Tommy Zhou. I am also talking about 40A 2B Roman numeral 2. Now, looking at the Chinese version and the English version, they both say, as the legal advisor said, the spectrum covered is very wide. Now, I will not repeat what Mr. Chen Chi-chun said. I agree with him. Now, when the person's gender is transformed, and then he gets the marriage certificate, and then there's an interval of time before the person gets married. Now, if you merely look at now you can look at the affidavit, but I will come back and say to you that religious bodies will not, well, if that person is going to get married in a place of worship, the church will probably look at the baptism certificate or whatever it's called. Now, when the pastor baptized that person was female, and the pastor knew her, and then the person has transformed his or her gender, and the pastor knew that person all along. He knew that something has changed in that person, and that person now claims to be a male. So the pastor doesn't just look at the ID card. Now, just now, Chen Chi-chun asked a question. Now, if something has changed in between the time of the ID and the time of marriage, then shouldn't there be a process whereby a doctor should certify that his genital constitution has been unchanged between the time of getting the ID and the time of marriage? If by some accident the constructed penis was lost, or that genital organ was not accepted by her body, now how do you determine that she is now a male? Now she no longer has that penis, but she just feels that she is male. Now, the intention of the bill is based on the CFA decision, for which medical opinion has been considered very carefully. Now, Dr. Yun also explained very carefully in the committee that the person concerned has to receive a long period of diagnosis and treatment, psychological treatment, hormonal treatment, and at least 1 or 2 years of real-life experience before the final sexual reassignment surgery. And the court has looked at the evidence and considered that this is an irrevocable surgery. So it is a permanent change. Of course, later there may be various occurrences. Now, if the person has done something to change the situation, then he has changed the situation, and he will not meet the requirement, and he will no longer be able to say that he has met the requirement. So when he made the affidavit, he has not met the requirement, so the marriage is not valid. Now, whether the marriage is valid is another question. Now, we do not question that certain things are irrevocable. If something has been excised, can it be repositioned? Now, we have cases where a penis has been cut off and later been sewn on back again at after a certain time of interval. Now, Roman numeral 2 is not same as Roman numeral 1, where it's the ovaries and uterus can be removed. Now, if when he got the marriage certificate, he had a penis, but that form of penis has changed. In fact, the penis is no longer there. So there has been a change. In that case, the marriage is no longer valid, and the female side may raise the point that the penis is no longer there.
And the marriage may be voided. But now, you're saying that he's got an ID card to show that he has reassigned his sex, and it is accepted by the government. And then will be 3-5 years after his marriage. Now, I'm not talking about what he has to do 3-5 years before his marriage, but after he's married. Now, if he has done surgery many years ago, and by the time he applies to get married, will you do anything to ensure that the penis or some form of a penis that has been constructed in that person still exists on his body? Now, you're saying that no such procedure is needed. I want you to answer this question first before I talked about what's meant by some form of a penis. Thank you. I think that can be addressed by improving Section 48(1). Now, it says if a person has received a full sex reassignment surgery, then the person is to be treated as being of the sex to which the person is reassigned after the surgery. It's just like what Mr. Ray Chen said. A person has gone through an SRS, she's turned from a male to female. Then, for whatever reason, she undergoes another surgery to become a male again. Now, there is nothing in this clause to require that the person has still to be the sex he is reassigned through the SRS. Now, whether it is from male to female or male to female, what if the person reassigns his sex again? Then what will happen? Under Section 48, can the DS provide a response? Dr. Yun, the expert in this field, explained to members, according to his clinical experience for so many years, medically, it's very clear as to how some form of a penis can be constructed, although different persons may have different requirements leading to a difference in the effect. And I have not heard from Dr. Yun that how an organ already constructed can become non-existent. He did not talk about such a case. Now, if a person deliberately or objectively decides to do another surgery to change his sex again, it's a separate issue. Now, we can't say that because the person has already done such a surgery, then irrespective of whether he has changed his sex again, he can still be eligible to get married. Now, if the ID is already changed, he will be treated as being the sex to which he has been assigned, you cannot examine him physically unless there is objection. Otherwise, you cannot carry out this procedure. Now, if he's changed from female to male and he only applies to be registered after a while, then you have to follow the normal procedures. You can only take the sex on the person's ID card as proof. So even if he's already changed from a female to male and the sex on his ID card is already changed, even though he has done another operation to revert to his original sex, the sex will still be what is shown on the ID card. Well, as soon as he has done the surgery, he will have a medical certificate. It's true that the presumption is to take the ID card as the proof. Unless there are suspicions, we will not carry out further examination. So the sex as stated on the ID card will be taken to be the sex of the person. I still have further questions. Now, you assume that the person has turned to a male, and for whatever reasons, perhaps an accident, he has lost his penis. Still, he has already complied with the requirement under Section 40A. It's just that for whatever reasons, he has lost his penis afterwards. It's just like the case of a man who has lost his penis in a traffic accident and he applies to get married. The situation is just the same. The question is, when he make that affirmation, whether he has carried out a full SRS, and if he has got a medical certificate to confirm that, and he has got an ID card to confirm that, he should be allowed to register under the MO. Mr. Tommy Cheung, if a person has got the SRS done in another country, I'd like to know whether there are different standards adopted by different countries. Now, under this ordinance, do we accept a person who has carried out a full SRS in another country? I'd like to know whether there is a global, a uniform standard for an SRS. This question was asked and answered before. Now, in most countries, the medical certificate will list out what surgery he has gone through and also the standards. And if we have any query, we can ask HA to re-examine physically the person. But usually this is not needed. Mr. Tommy Cheung. Because we don't know how many countries will provide SRS in the future. Because a place may want to invite or attract investors to invest in things that is not allowed or cannot be done in another place. A country may simply state that a person has got his sex changed, very simply. So according to the administration, if you have got documentation from other countries saying that certain items have been done, and then you will check and you will assign his new sex in an Hong Kong ID card. Now, this is a digression from our MO, so this is very complicated. Now, if our local authorities have checked the items stated on the certificate and ask our HA doctors to conduct a physical examination. If it is found that, well, the removal is not complete or the construction is not complete, then approval will not be granted. Now, I don't think they have given me a full answer. Are there really international standards? Will you check the items and see whether they comply with our standards? And where can we find a code or a list of standards? Otherwise, there may be confusion. Now, this is not about the marriage ordinance, but this reassignment can give rise to certain other issues. Now, I don't know whether this question has been asked previously. Why is it that they need only to construct a penis, but not the testis? Sorry, I got the Chinese name wrong. The testis. Why not construct the testis as well? Well, the person may show you a passport and with the sex changed. If the passport is already a male when the person was biologically a female, will you just accept it, or do you still require a medical certificate? My understanding is you will accept the proof provided by that country, and no other arrangement is needed. Am I correct? Yes. I think Dr. Yun made it clear that we don't have any standards in Hong Kong. We follow international standards. And I think Dr. Yun explained what is meant by a complete SRS. As regards our own legislation, we have set out what have to be removed and what has to be constructed. Why? There is no need to construct testes where it is something for the medical sector, not to be determined by our registry of person. If a male is changed to a female in other countries, well, they may not adopt our standards, but it's already confirmed that the person is changed from female to male, and the sex is so indicated in his passport. Will you allow that person to get married accordingly, or are we going to adopt our own standards? We adopt our own standards because in some other countries, even without any SRS, a new document, a new identity can be issued. But for us, we have made it very clear that there is a surgical requirement, and regardless of the origin of that person, he has to fulfill these requirements. How do you know? The person is required to make an affirmation, and he has to read the detailed requirements before making that affirmation, and we explain to him what is it about. Our standard is regardless of whether the surgery is done in Hong Kong or overseas, the standards are just the same. If a person wants to get married, then he has to fulfill these requirements. Otherwise, the marriage will not be valid. So when he intends to get married, we invite him to make an affirmation. And if the bill is enacted, we will tell him very, very clearly what's in the bill to avoid any misunderstanding. As regards organs to be reconstructed, I think this is a consensus. It represents a consensus of the medical sector after many years of evolution. For instance, a man would not need to construct any ovaries, and a female doesn't have to construct testes.
Mr. U.C. Wing, I'd like to ask, under what circumstances will that person identify with the new gender? Is it by affidavit or at the time of getting the ID? Now, in existing law, there is no specific provision on recognition of gender. Now, there is no general law on recognition of gender after sexual reassignment surgery. So this matter is being looked at by the working group on gender recognition headed by the SJ. Now, so the bill is to address how, under what circumstances can this person get married in Hong Kong, because the CFA has made the requirement very clear, and we just put it clearly into law. Now, the person, after surgery, is he recognized to be of the new gender at the moment the surgery is completed, or is it at the moment that he gets the ID? Because there is a question of status during the interim period. That's basically the procedure. Of course, he has been diagnosed and treated for a long period of time, and then the surgery is done and completed. The surgeon concerned has to certify that the surgery has been completed for the sexual reassignment, and then the person, well, usually he wants very much to change his ID card and the travel document. So when he comes to get registered for marriage, he would get the ID, bring the ID card, because otherwise he cannot come and get married, come to be registered. So the person is formally recognized to be of the new gender at the moment he gets the ID. Now, in between the moment of surgery and getting of the ID card, what gender does he belong to? The law says very clearly, after it's all done, then he becomes a person of the new gender. But this is only recognized after he gets the ID card. But in the interim period, the legal protection, or if he or she gets a divorce, then before he gets the ID card, then he would be in a marriage of the same sexes. So this is interrelated. Now, apart from the marriage ordinance, there is the Registrar of Persons ordinance, in which there is a provision saying that the ID card holder, if there is any material particular on his ID card has been changed, and that particular might be his gender, then he has to report to the immigration department the change as soon as that change has been effected, or as soon as possible. Now, this is a fact. Now, if the surgery has been done and he has received the medical certificate, then under the Registration of Persons ordinance, he has to update the data. That is not a difficulty, so he can get the registration very quickly. But a third party might question his status in respect of inheritance, etc. Now, the provision is very clear. As soon as the surgery is done, he is of a new agenda. But there is an interim period before that person gets the ID. Now, it may be 1 month, 1 week, and in the interim there is a legal vacuum, whether for the protection of that person or for other persons. Now, in the drafting of 40B, we considered this issue. Now, the Registrar of Persons has to look at his proof, documents of proof. Now, so this is a simple procedure. Now, so the procedure ensures that that it has been done, and the ID card reflects his gender. Now, this is a practical issue. Now, the surgery has been done, but he has not received his new ID card. In the interim, what is his gender status? My understanding is that his status would be still the same as on his ID. So is my understanding correct? He has to be registered at the immigration department before he is formally recognized as having undergone a gender change. And before that, he would be treated as if he is still of the old gender. In the absence of a specific legal provision to deal with this matter, that understanding is correct. He first has to undergone treatment and diagnosis, undergone surgery, and then he has to get the medical certificate, and then he has to update his ID card. And only when the process is completed will his gender reassignment be completed. Now, there is a working group to explore the entire process. So that is to be dealt with by the working group. Chen Chi-chun. Now, I don't agree with the administration on three accounts. Now, the administration said that the person has undergone SRS. He would be very glad to update his ID card. That's not true, as I understand it. I know persons who have been reassigned from female into male, but she feels that she shouldn't be male, she should be X. That happens abroad. So there have been persons who have undergone SRS, but they haven't gone to change their gender. Now, also, how much SRS has to be done before it qualifies? There is no international general standard, but there is a tendency that every year there is some country which leaves out mandated removal of ovary, etc. Now, thirdly, for male to have been reassigned into female, and it can not be reversed. That is very difficult. Now, for female into male, the penis doesn't serve its function, or there might be a malfunction. Then the person might want the penis to be removed altogether because it serves no function. Now, the government is giving us two sets of standards. The government says it depends on the moment the person gets the it all hinges on his getting of the ID card. Now, the doctor issues his certificate, he goes to get an ID, and he acquires his male gender. And then later on, he thinks that the organ is unwieldy, or it's not good looking, redundant, then it's removed. Now, the administration said that the affirmation or the affidavit at the time of marriage, that is definitive. Now, after you get married, now you don't like the new penis, then you have it removed, then the law doesn't care. Now, as long as he has got married, then the new gender holds, and there is no legal hazard, even though the penis is no longer there. Now, on the getting the new ID, we are talking about male into female, the two male and female. There is no case of X. The court has not dealt with this matter, and there is no general conclusion in the medical sector, so this is really irrelevant to our discussion. Now, the existing requirement has been adopted by us for a while, and it's the same as now. For male into female, there has to be removal and reassignment, and same for female into male. And we are merely encoding the principle set by the CFA. Now, on the third matter, now the member says that a person afterwards deliberately undergoes a surgery to remove a reassigned organ, then it doesn't meet. He doesn't meet the requirement as specified in the bill, so the marriage may not be effective. Now, if the organ is removed because it has detrimental effects, will the marriage still be effective? Now, I think it's a different matter if he wants to remove it just by his wish. Now, if there are some circumstances outside the control of that person, maybe an accident or injury, then it may affect the person's gender. So the two are different, whether it's out of his control or that person deliberately undergoes a surgery. Assistant Director, up to now, I haven't heard the experts like Dr. Yun saying that after reassignment, the gender can be reversed. Now, maybe I wasn't clear just now. At the time of affidavit, we explained to the person who intends to get married what constitutes a man or woman, and looking at our provisions. Now, if that person had undergone a full SRS, and before he gets married, if there's an accident or circumstance outside his control leading to the loss or removal of the penis, then from the perspective of the Registrar of Marriages, we feel that it's the same as in the case of a person born as a male and losing his penis from traffic accident, and then coming to be registered for marriage. In that case, the registrar will still register his marriage. Now, if the member has a further question, we can only suggest that person ask his legal advisor. Now, the doctor has issued his certificate, and you are saying that is treated the same as if it's due to the organ has been removed as due to traffic accident. Now, in that case, what's the point of legislation? Legal advisor? Now, I want to point out that in 48(1), now there is no mention of the matter of accident and deliberate removal. What's the difference?
Can the administration point out where we can see this difference? Assistant Director, if a person deliberately removes his constructed artificial penis and ask for asked to register to get married, I have to consult a relevant legal advisor. Even if we give him a registration, that doesn't mean that it is okay. He may still have to go to the court to clarify whether his marriage is valid or not. Now, looking at the provisions myself, the Registry of Marriage, the Registrar of Marriage will not see any difference in the case from a case where a male lost his penis in a traffic accident, and whether a person will remove his penis and ask to get married as a male, I don't know. Well, there is nothing in the law to prevent a man who has removed his penis to get married. Exactly. Yes, I agree with the assistant director. Now we'll talk about Section 48. I hope members can focus on the provisions. Yes, that is about the penis, but that question is already answered. Now, if you want to refer to another act, well, since you have started the discussion, I didn't want to stop you, but let's focus on Section 48. That means so long as a person has constructed a penis, even though he has lost it in an accident, it's okay for him to get married. Is that right? Your understanding is just like someone who has lost his limb. You will not affect this. Then I will ask people to just sew on an artificial penis and then apply to get married. Assistant Director, there can be another scenario I can think of. An ordinary man may have to remove his penis due to some disease. I think it's just like the case of the need to remove an artificial penis because of rejection or ulcer. Well, for an ordinary man who has lost his penis or testis, he will not then have a vagina and become female. President Leung, now I think I have to put 40B into the question, if you allow me. Yes, we have already touched on 40B. 40B is related to what Mr. Ray Chen said. In the absence of evidence to the contrary, the sex of a party to a marriage is shown on an identification document. Now, for the case of transsexuals or scenarios referred to by Mr. Ray Chen, now Mr. Chen said that he would ask these people to remove the penis. No, this is not allowed because that will mean an intention to mislead the registrar. I think Mr. Chen Kim-po will tell you, you cannot cheat insurance compensation by inflicting injuries on yourself. An accident is different from self-inflicted injury. All right, the whole discussion is about whether it should be a full SLS or it may not be appropriate for somebody to conduct a full SLS. Now, people can come out to submit evidence to the contrary and say that a person is not of that sex. So, Mr. Ray Chen, we cannot expand the scope here because a person might have a spouse before he changed the sex, and if he has not gone through full SLS, his spouse may come out to provide contrary evidence. And what if he has already undergone a surgery, but he is still dressing in his original sex? Well, people may oppose to a marriage due to many reasons, emotional reasons, whatever. So this can be very complicated. If it is not very clear-cut, then it's easy for people to submit contrary evidence. I remind members to speak in either English or Cantonese, otherwise it would make life difficult for the interpreters. Yes, our requirements are very clear. Is the requirements under 40A2 small a and b. So the question is whether the person has removed the original sex organs and reconstruct new sex organs. The medical certificate is clear, and whether the person can be registered to get married will depend on this. The principle from the CFA is very clear. Removal and reconstruction in an irreversible surgery. I think it is already accepted by the medical profession that a surgery cannot leave any leeway for a further reassignment. And I think from what we've heard from doctors, it's a very vigorous and serious assessment. The procedures would be very clearly explained to the person concerned before it is carried out. I don't think there will be any ambiguity. Mr. Richard, speakers off mic. I'm not. I am just challenging the administration to make the provisions are clear. I'm not appealing to the public to construct, to sew on an artificial penis and has it removed after marriage. Yes, I agree that the removal of sex organs is irreversible, but for reconstruction of a penis, well, it is not really irreversible because there may be rejection or inflammation and so forth. Now, even with inflation, it may be a bit useful, but for some penis, it may not even be useful for excretion, so for urination. So a person, if he thinks that the artificial penis is just for window dressing, or if the outcome is not that desirable, he may apply for removal of the penis, not because he wants another reassignment. So I'm asking the administration to reconsider whether the clause here is clear enough. The administration has been giving us the same answers over and over again, but I really want you to seek legal advice to address the concerns raised by a few of us here. 40A2A Roman 2 regarding the construction of a penis. And as a member, or rather legal advisor, asked about the definition in 40A1, whether it is acceptable so long as a person has received a full SRS. Which one should prevail, the medical certificate or the affirmation? Because a doctor won't know what a person will do after the surgery here. A person may go to Thailand for another kind of operation because the medical certificate will prove what has been done at this moment, and 10 years down the road I make an affirmation to get married. You don't know what has happened in the 10 years in between. So which one will prevail, medical certificate or the affirmation? The affirmation is to affirm a fact, and whether the fact agrees or complies with the requirements. A medical certificate can be fake, but even if it is fake, or the partner may raise the point that the collaborated to make a false affirmation. So the point of affirmation is to affirm whether the facts are true at the point of affirmation. Dr. Priscilla Leung? Under 40B, there's the phrase, in the absence of evidence to the contrary. Now, a person has already got a medical certificate, and your presumption is in the absence of evidence to the contrary. Now, for instance, if he so has a sex characteristics pointing to another sex, or maybe his behavior is still conforms with another sex. Well, so can you tell us what is meant by contrary evidence? So can you please tell us what is meant by evidence to the contrary? Thank you. We have come across cases where a person came to Hong Kong with a British passport, and he stated very clearly that he had not undergone any SRS. However, his new sex had been accepted by the UK and so indicated in his passport. So on record, we really knew that he had not carried out an SRS. We could not take the sex on his passport. So that's evidence to the contrary. Mr. Ray Chan, I also like to follow up on this point about evidence to the contrary. So the DS told us a case where a person showed him his passport. How do you know that he has changed his sex? Is it because when he came last time he was of a different sex, and you would ask for a medical certificate or a document to prove that he had received full SRS? Now, if he could not produce that, you would use the sex on his passport when he first arrived as evidence to the contrary. Now, if he is a Hong Kong resident, we have already got records for changing his sex on the ID card. We will not ask again. But if it is a foreigner, he may not know our laws well. And if according to our record, he had entered Hong Kong under a different sex, we would ask clearly whether he had performed such an operation. And if he said yes, and if he is willing to make an affirmation, we will not ask for the certificate. But most people would tell us that he has not performed such an operation, and is it okay for them to get married in Hong Kong? Well, even before the enactment of this bill, this should not have happened, because you would consider the biological sex of the person. Because before this bill is enacted, there should not be any question of a medical certificate, but the DS said as if there was indeed such a case. DS. Well, in the case of W, she told us that she had performed such an operation. She had received such an operation and asked her whether the registrar would allow her to get married. And we said no. And meanwhile, there were also people who inquired with us.
No, in the real life situations, somebody didn't tell you what happened in the past, and then you registered the marriage without knowing. So in that case, will the marriage become ineffective, Assistant Director? Now, we are responsible for registration of marriage. Now, as for the marriage is effective, now if that person deliberately tries to hide certain facts, the ultimate is to be decided by the court. But that person is not hiding. There's Now, suppose the law says male and marriage is between a male and female. If that person has undergone a surgery, then according to the W case, now before the W case, now are there cases where there has been if a person has undergone full SRS and then the law now comes to effect, and then can the law and then can the principle apply retroactively? Now, if he tells us that if the Registrar of Marriage does not know the fact, and then if there is a dispute, it ultimately is to be decided by the court. Mr. Paul Chair, now I might have asked this question. This question might have been asked before. I was in another meeting. We are now at 40A and B. Now, I'm reminded by the document before me. Now, looking at the document Annex D, the content of the affidavit, the administration says that the affidavit is to be voided, to be altered to include the wording that is underlined. In Section 40, the legal requirement, there is a footnote saying that under Section 40A, there are certain provisions. Now, Section 40A is in two sentences. Now, the first sentence, the first clause says that a person has gone full SRS, he or she would have met the requirement under marriage ordinance. Now, the second meaning is that the references to male and female under MO and MCO would be interpreted accordingly. Now, I think this is redundant. The CFA decision has been unduly strengthened or enriched in meaning. Now, the CFA, if CFA has opened the door, then here the door is closed. The certain persons would be excluded. Now, I am concerned that in the past, the CFA has said that the provisions are unconstitutional. Now, if we want to uphold the CFA decision, paragraph 1 is enough already. There's no need for paragraph 2. Here, you seem to be saying that paragraph 1 is necessary. You don't have to have paragraph 2. Now, so as I said, 40A has two meanings. One is to open the door, one is to close the door. And the Annex D footnote refers only to paragraph 1 and not to paragraph 2. What's the reason? Now, as I explained, now the CFA order is very clear that 40A bracket 1 in the latter part, the references to male and female, if we do not add the part that a person who has undergone a full SRS is entitled to marry, and in that case, if we merely explain by the marriage by the original sex, then it's unconstitutional. So we think that our version is very clear in codifying the court's decision. Now, it doesn't conflict with the amendment to the affidavit. The SRS requirement has been made very clear, so there's no conflict. Now, when I read 40A, first paragraph, as I said, there can be two meanings. The first is that after full SRS, the person whether meets the definition to get married, and Annex D uses this first sentence, and then the door closing part is that in future the references to a man and a woman in section 40 bracket 2 and the references to male and female of in MCO are to be construed accordingly. So it is not an ultimate definition. There is a door open. So this door closing provision has been unnecessarily excluded the persons who have undergone SRS. Maybe you have not understood me. Now, our wording is to serve the court's decision. We are not trying to close the door. Now, if someone hasn't undergone full RS, the court hasn't drawn any conclusion on that person. The clause 40A is merely to represent the court's decision. There is no purpose to close the door in the future. Now, if in your words the door is not closed, there might be greater controversy. Now, that is a matter to be discussed by the group headed by the SJ. Now, the bill, as I understand, is to enact the decision by the CFA. The CFA hasn't closed the door, so the government is taking a redundant step. And my concern is that when there are future challenges, the CFA will again say that the bill is unconstitutional. Now, if you say that the full SRA has been done and yet you don't close the door, then you might lead to a challenge that is unconstitutional. Ms. Priscilla, we are talking about the marriage amendment bill. Now, if we are expert in court, it might be in respect of legal action regarding inheritance. Now, somebody might want to prove a marriage is ineffective. So a person might have undergone surgery abroad and Hong Kong doesn't recognize it. Now, we have registration, and then a person challenges the marriage as being effective, that it doesn't meet the Hong Kong requirement. So it might lead to controversy. Now, for 40B, there might be evidence to the contrary when when people are fighting to gain control of inheritance, they want to prove the marriage is ineffective. Now, even if the marriage is effective, is registered, it might still be challenged as remarriage. Now, so if you are not clear, it may cause confusion. There may be issues of rights raised in the future. So I think the direction has to be clear, and on whether the door is open, and then we have to follow it. Now, I hope that it's the CFA can listen, can hear us. Now, even if a person is married by civil ceremony, it has to be made clear in court. So we have to tell them it has to be narrowed down, because otherwise there may be a lot of lawsuits in the future. So I hope the SJ hears this. Now, there may be a lot of controversy and dispute. Now, the evidence to contrary. Now, I have come across this many times. Now, you might have a doctor who signed the certificate, but I might get another doctor who says that the surgery has not been a full one. Now, you say that maybe it's a psychological change, the gender change has not been complete, or there may be spouses or lovers trying to prove that a marriage is ineffective. So I think the provisions have to be narrow in meaning to reduce the chance of future disputes. Now, I hope we come back to the discussion of 40B on what is unclear. Anything to add? Ray Chen? I agree with Paul Chair. Now, 40A bracket 1 is already sufficient to open the door as the CFA has set out. So I do not think that that it will make any difference if we delete 40A bracket 2, because the gender change is according to the doctor's certificate that the full SRS has been done. Now, you take that certificate to get the gender change at the registration of a person's office. Now, so I do not see why 40A bracket 2 has to be included. Now, Paul Chair says that this is a door closing provision. Now, the CFA hasn't spelled out what is a full surgery, and that may lead to lawsuits in the future. Now, how do you set out the administrative guideline? Now, it's proposed by a medical expert, and so it's up to the discussion by the experts. Now, 40A bracket 2 AB is the issue in all our meetings. I think we need not discuss this any further. We are now coming to the provisions. Now, so please answer the second question, but not the first one. The provisions have to be clear, because it has to be spelled out what are the criteria to be met for gender reassignment, and the CFA decision says very clearly that the original organs have to be removed and new organs have to be constructed. So we have to reflect verbatim the CFA decision.
Yep.
All right. Page 2. There's an amendment here. Mr. Wu? Clause 4 is just a technical amendment to amend the schedule. If a widowed person receives an SRS after he is become widowed, then because in Schedule 1, in the notice of intended marriage, the marital condition has to be supplied, and there are options: bachelor, widower, or divorced person. If a person, a widowed person, wants to get married again after an SRS, the word widow may not be suitable, so we say a widowed person. Okay. Page 3, the same. Page 4, no amendment. Page 5. All right. Oh, my. Well, the Chinese song now, meaning the spouse has passed away. This is not really a status. Why don't you say 喪偶者 in Chinese, meaning a person who has lost his spouse, or a widowed person, meaning. In response to Mr. Ray Chan's question, we just want to tally with the other phrases in Schedule 1. Now, if we look at Schedule 1, bachelor in Chinese is rendered into 未婚, and divorced is changed or rendered to 離婚, meaning the same. So we want to use the same part of speech. I agree that if you want us to have an exact or equivalent of the English phrases, well, we have to change the parts of speech of the Chinese phrases. But because for consistency sake, we've decided to use 喪偶, which is a status. All right, since so you use what is meant by 喪偶, meaning a widowed person. What do you mean by 喪偶 in Chinese? I think the same phrase, the same Chinese phrase has been used in other legislation. It's just the same as someone who is a widow or widower. Because I think now, of course, 喪偶 in Chinese is a status, meaning the person is, the status is widowed. But if you want to follow the same part of speech in the English term, it should be 喪偶者. 者 is the person. Well, are you talking about the status? I think the Chinese is okay. 喪偶is a status. I think you should have a proper interpretation for the Chinese term 喪偶, meaning widowed. All right. No change to page 6. No change on page 7, page 8. The same. To replace a widowed with a widowed person. Okay. So we have completed clause by clause scrutiny. Now, we have to deal with the CSAs. We have got CSAs from members. I think we have a CSA from the administration, right? Can the administration brief us please hand out the CSAs. Thank you. Well, as we said at the start of this Bills Committee, the purpose is to implement the CFA ruling to turn it to statute law. So we hope that the legislature can resume the second reading debate of the bill so that we can put CFA's ruling into our statute law. If members agree that the bill can resume its second reading debate on the 9th of July, we'd like to move an amendment to specify the commencement date, and that is the 17th of July 2014, so as to be in line with the commencement date of the order of the CFA. So we don't need the Secretary for Security to gazette another notice for the commencement date of the amended ordinance. Any question, please? No? So you want to have it passed on the 9th of July. Can we discuss this? Oh, I think we have to deal with the CSAs first. We have got CSAs from Ms. Cyd HO and also Mr. Dennis KWOK, but both are not present in this chamber. So the CSAs were provided to members before today. So I'd like to see whether members have any comments or questions on the CSAs. If not, can I discuss Mr. Dennis KWOK's CSAs? Just a comment. He proposes a sunset clause, and that is for the two sections to expire at midnight on the 31st of July 2017. I think such a sunset clause for the MO is very dangerous because the purpose is to allow people to know how they can register to get married. If certain clauses or sections will expire on a certain date, this is very unsettling because we are all scolding the CFA because the court has given us 1 year to legislate, even though we haven't got any consensus. I fail to see how in 3 years' time we can have a consensus on the way forward. So I myself find this sunset clause very objectionable. Well, we can only discuss the content of member CSAs. It's not for us to say whether we support or oppose it, because members are free to move their CSAs. We cannot stop them. Yes, let me supplement further. There are 2 points. Second point, to require the Secretary for Security to conduct a public consultation prior to a certain date. So the SFJ will have this statutory duty to conduct a public consultation. Again, I disagree. This is a political issue. Whether a public consultation can be conducted has to be discussed and decided by the Council first. So it's not possible to say that the public consultation must be conducted prior to the 1st of 2017. And 2017 will be the next term of Council. This makes it even more difficult. I don't think this is enforceable, and I really disagree to this mode of amendment. I also like to listen to the administration's view. Subclause 2, Prior to the 1st of August 2017, the Secretary of Justice shall conduct a public consultation on the legal and social issues concerning the rights of transsexual persons in Hong Kong and other related issues as determined by him, and cause a report on the results of the consultation with recommendations on any legislative proposals arising therefrom to be laid on the table of the LegCo. Even if the Secretary for Security follows this clause, that doesn't mean that there will be certainly a bill submitted and passed by the Council, right? Regarding Mr. Dennis Kwok's motion amendment, there are two things. First, to create two sunset clauses, and second, to require S4J to conduct a public consultation prior to a certain date. We understand that the amendment bill here is to reflect the CFA's ruling here. It is inappropriate to create a sunset clause for such a section, because the CFA's ruling is really part of our law and it has to be followed in our day-to-day work. With the sunset clause, I think it will create a lot of confusion and ambiguity for people who have received SRS and who intend to get married. Regarding the work of the S4J, in the relevant panel, the S4J explained that he would review all issues related to gender identification, and full consultation and considerations are needed, and there may be very different views from different sectors of the community. So we disagree that we should have a deadline put in the bill. I'm not asking whether the administration agrees or not. I think the administration understands that the purpose of Mr. Kwok's CSA is not really to make these two sections invalid. It's just used here to pressurize the S4J to do something prior to a certain date.
Even if the government does the work in bracket 2, it doesn't mean that the government will ensure that the new Marriage Amendment Bill of 2017 will be passed. Now, the government is actively doing the work on the study of gender recognition or sex recognition. It is a complex issue. We should let the working group have the space and time to do a careful study. Now, we are in agreement on the direction, but we think that we shouldn't set a deadline by law. Now, we may not support Mr. Dennis Kwok's amendment, but if the government demonstrates sincerity that it will come up with amendment or a review of gender recognition law before that, that would, of course, be better. Now, when the secretary of the interdepartmental working group came here last time, they said that the group has to look at many laws, and right now they hope that they will come up with a preliminary report in 2 years' time, and then they will issue a consultation document. Now, we are talking about the committee stage amendment. Now, on the table, we have two sets of amendments. The members who propose them are not here. So as for your views on the CSAs, we need not go into that right now. We have to end the meeting by 12:45, and we need to come up with a decision on the decision regarding the 9th of July date. Now, Chung Shikan and Tommy Cheung may have comments to make now regarding the amendments. Now, I'd like to ask the administration about Ms. Cyd HO's amendments. So altogether 3 members. So please address your questions to the CSAs. Now, as for the contents of the CSAs, you should ask them about the contents. Chung Shu Kan. I'd like to ask about a technical issue regarding for the legal advisor. Now, is there a previous case of asking the administration to do a certain act like a consultation? Now, such an amendment, will it damage the relationship between the legislature and the executive branch? Now, so are we requiring the administration to act in a certain way? Now, if the bill is passed, the administration has to do what it requires, then there's no flexibility, and then the enactment is complete. Then what is the meaning of? Is it meaningful? Now, when members or the administration propose amendments, now do we have to remind that such conflict with the working of the executive branch is inappropriate? Now, I'll try to answer the first question. Now, whether there has been past cases. Now, I am unable to give an answer to Mr. Chung on whether there has been a precedent. Perhaps the legal draftsman can assist. Now, as for issues on the political side, perhaps the administration can answer. Now, actually, when you make such a draft, you are interfering with the working of the executive branch. Now, maybe you have an obligation to tell the member that this will not work. Now, then the legislation may be passed, and then it turns out to be ineffective. Now, of course, the members can move an amendment if that's what he feels. Legal advisor? Now, I think such cases, even if there were such cases, would have been very rare. It's difficult to give an answer right now. We have to do a study. Now, if the CSA is passed, then the law, will it be meaningful at all? Now, you consult, and then what's the purpose of the law? Now, members have the have the duty to put these matters for consideration. Mr. Tommy Chow? As I said, I intend to make an amendment to exempt religious bodies from having to celebrate against their will marriage ceremonies for transsexuals to be married at their places of worship. Now, I'd like to ask the legal advisor. Now, of course, if the chairman says that the bill has to be tabled now, but I still might propose the amendment. I know the Secretariat will try to give their support, but I'd like to ask the legal advisor, now if I make such an amendment, should I add a 40C to introduce this exemption, or should I introduce it in 40B? A legal advisor? Now, on the provision to be added, we can go into that later, but in principle, we can introduce an amendment under Marriage Amendment Bill. How to introduce this exemption? Where? In the simple question, the legal advisor, can you assist Mr. Cheung on where the provision is to be introduced? We can assist. That's the general principle. Now, Chairman, I asked you before, but you rebuffed me. Well, your brows were knitted, so I take that to be your attitude. Now, colleagues yesterday and today support my exemption, proposed exemption. Now, Chairman, will this committee move this amendment instead of me? Now, I don't think the committee should make this amendment. If that's to be the case, we need another meeting. Now, if you move the amendment and everyone agrees that it should be done by the committee, I will be unable to stop that. But I think you can certainly move it, and then the legal advisor can assist. Now, people might say, if you want to move the amendment, why don't you do it yourself? Now, this is not just a proposal by the Liberal Party. We have heard this from many deputations in the public hearing. The Liberal Party feels that this is a reasonable proposal. And I also wanted to protect the lawyers as well. Now, the lawyers might find this against their religious beliefs. Now, Chairman, you might ask the colleagues here, now if everyone agrees that this is to be done by the committee, that's fine with me. But if others say you do it yourself, that's also okay with me. Okay, let's deal with this. Now, Mr. Tommy Cheung proposes that the amendment be done by the committee on whether the fact that religious bodies should be exempted from celebrating a marriage of transsexuals, involving a transsexual person. So, do we agree? If we think there's no need, then let Mr. Cheung do it in whatever way he wishes. So how many support the amendment to be done by the committee? Now, so we would not go for July the 9th. Now, even if it's done by the committee, we still need a discussion. Now, anyone agrees that the amendment be done by the committee too, in support? Against? Please raise your hands. 2, 4, 6, 6. Okay, I will do the amendment myself. We will end at 1:45. Ray Chen has a proposal. I will extend by 15 minutes. Now, if it's, maybe we can have a decision in time. Legal advisor. Now, I think it would be better for it to be done before a quarter to. May I ask for a the voting bell to be rung? Now, I have the right to extend by 15 minutes. I have not done that yet. So I will extend the meeting by 15 minutes. Now, at the last meeting, members strongly requested that a decision be made here at this meeting. Ray Chen, you have any other question? I would like to speak about Cyd HO's amendments. After this, I will ask members to vote on whether we support this bill to go to Council on 9th of July. Ray Chen, Ms. Cyd HO has come up with two amendments. The two are similar. First is to delete all the requirements about the surgeries. Secondly, a series of exemptions. Now, if those exemptions are passed, then the surgery requirement will be quite purposeless. Now, unneeded. Now, on the change of sexual status, there is no change in administrative guideline. You can let somebody who has undergone less than a full SRS to be registered for marriage, but if a person is to be registered for marriage, he has to be met. He has still to meet the conditions of 48 B. A and B. Now, if the bill is passed, if these amendments are passed, there wouldn't be much effect on Hong Kong people. But foreigners would be impacted because in the UK they don't have to undergo surgery before they can change their sex status, so they can come to Hong Kong and get married. Now, the administration, I think Ms. Cyd HO has made two proposals. They both far exceeded the scope of the CFA decision. So I think we need not go into discussion on whether we can support this. Now, if members supported the amendments and what would happen from the administration side? Now, this is a hypothetical situation. Now, the important point is that the situation outlined in the amendments far exceeded the scope of the bill. In that case, we will ask members to vote. Now, the administration, the date proposed is 9th of July, that if you want the administration to take this bill to second reading on 9th of July, will we support this date to be tabled to the Council on 9th of July? If that's so, then we will need to make a verbal report to the House Committee on the coming Friday, 20th of June. I ask for a bell to be for the voting to be recorded. So the voting bell will ring for 5 minutes.
請大家注意咧，我哋跟住落嚟嘅表決係。
Please note that we're going to vote on the following: that this Bills Committee supports the resumption of the second reading debate of the Marriage Amendment Bill 2014 on the 9th of July. Now, if you are for the second reading to be resumed on the 9th of July, you press the yes button. Otherwise, you press the no button. So, Chairman, the administration wants to resume the second reading debate, yes, on the 9th of July, and you're asking us whether we support it or not. If the most of us doesn't support it, all right, this is for the administration to decide. So they want an indication from us. The administration wants to resume on the 9th of July. So we also have to show our position to the House Committee that this Bills Committee supports the resumption of the second reading debate of the Marriage Amendment Bill 2014 on the 9th of July.
Okay,
those who are for the motion, hands up, please. Yes, I'll read out the names and you can put down your hands. KWOK, UC Wing, Tony Tse, Chen Kim Po, Regina Yip, Starry Lee, Christopher Zhong, Martin Liu. Those who are against, hands up, please. Tommy Chung, Emily Lau, Helena Wang, Ray Chen, Cyd HO. All right, please announce the result. Any abstention, please? All right. 14 members present. I didn't vote. So 30 members have voted. 8 for, 5 against. So report to the House Committee. The Bills Committee supports the second reading debate of the bill to be resumed on the 9th of July. If members have CSAs to move, let me remind you that the 28th is the deadline. Even though you have not removed any proposed any CSAs so far, you still can do so before the 28th of June. And the administration has to give notice to the Secretariat of the Council for the bill to resume its second reading debate on the 23rd. And then on the coming Friday, and that is the 20th of June, I will give a verbal report to the HC. All right, AOB. We don't have any AOB. So the meeting is adjourned, and the work of the BC is also completed. Thank you.